views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, coming up on this edition of Today's Verdict, do you know what intellectual property is? Well, you should. Tonight we're going to help you understand all you need to know about copyright, trademark, and patents. And everyone makes mistakes, even attorneys. That's why legal malpractice is an important area of the law that you should know about. Tonight we will give you ways to protect your right to sue an individual and make sure someone is on top of your lawsuit. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. All right, well, hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict and check us out at BronxNet.tv/BronxLegal. And last, but certainly not least, don't forget to tweet me at David Lesh. Well, unfortunately, when you have a lawsuit, you often are unaware if your attorney is taking the proper action to make sure you do have proper representation. Well, today we'll learn all about legal malpractice with attorney Jeffrey Bloom. Jeff, thanks for being here.
My pleasure.
All right, well, attorneys do make mistakes. I'm sure you see it in your office. Do you see a rise in these types of cases?
You see a lot of phone calls
All right.
from people who are unhappy with their results. But to win a legal malpractice case, it's not just the lawyer made a mistake, it's that he was negligent, which is a standard, and then you have to prove that the underlying case was also a winnable case. So you don't take as many cases as you get phone calls from, but you see it. And you see it a lot because lawyers are taking in too many cases and sometimes and can't handle them. And
I guess that, if you have a small firm, you're just juggling so many cases at one time and one slips through the cracks, and the next thing you know, you have a malpractice.
You have statute of limitations problems. You now have court issues that courts are putting strict deadlines on discovery and on things. If you miss it, some of these courts are dismissing cases.
Give me an example of maybe a type of case that you're working on.
Well, I have one now, which is a case that you would all think is the most obvious case in the world. A man comes to a hospital, an upstate hospital, complaining about chest pain, and the nurse sees him and says, "We need a cardiac consult." 4 or 5 hours go by before the cardiac consult gets called. No one calls initially, and the guy dies, unfortunately, at the scene in the hospital of a heart attack. They sue the hospital. The lawyer who has the case never starts the lawsuit. Statute of limitations for a wrongful death case is 2 years, 2.5 for malpractice. Statute runs, cases hasn't been started on time. The lawyer compounds things. This is a lawyer, a partner in a firm, by actually forging a judge's signature on a document that says the case is restored. You would think it's the most open and shut case there is, and on the legal, it's not defensible. But the case will be defended on whether or not the underlying case was winnable.
So it's almost two trials in one.
It's two trials in one.
It's whether the attorney himself or herself was negligent in missing the statute or whatever it was, and then the part of the case is, the second part is whether that attorney would have been successful anyway. Am I correct?
I have to prove the underlying medical malpractice case, and I have to prove not only that the hospital was negligent in not getting the cardiac consult there, but because this was a massive heart attack, would it have made a difference?
Now, how does the client even find out, by the way? Many clients don't even realize that a statute has been missed or something happens. How do they generally come to the understanding that there's been a problem?
At some point, the lawyer calls up and fesses up and says to them, "I made a mistake." In this particular case, the client called the law firm up, and the partner in charge of the case wasn't there, so another partner went and said, "I can't find your file anywhere," and that's what led to the discovery.
Now, attorneys I have malpractice insurance. We should all have malpractice insurance. What's the amount that usually covers these types of cases in terms of a financial amount?
The minimum amount that I see a lot of lawyers have, a lot go bare. A lot of
Bare
lawyers,
meaning a lot of lawyers just don't have
have
it.
malpractice insurance, which
Wow.
is craziness. But a lot of them only have $1 million in coverage, which 10 years ago sounded like a lot of money. But in this day, with the inflation and with people understanding lost earnings and concepts like losing a family member, it's not enough money.
And you have the right, as an attorney, bringing an action against another attorney to look to private assets.
Yes.
You don't have to just get the insurance monies. They have a house or a business or a car or whatever it is, you can go after that too.
Several years ago, we had a case against a well-known lawyer who passed away, and his estate had to contribute to the settlement.
Now, when you're prosecuting the underlying action, right? Forget about whether the attorney's been negligent, which
Right.
is hard enough. Do you have to get your own experts now to prove the
Yes.
underlying action? You have to do that all yourself.
I have to get my own expert. In this case, I've gotten a cardiac surgeon who's ready to come in and testify why it would have made a difference, at what point, what they could have done. In this case, they could have done an angioplasty and cleared the blockage, but you need to be able to prove that.
Now, what type of excuses does the attorney have for not being able to prosecute the case in time? Can they blame it on the client at all? The client didn't give me the information I was supposed to. Maybe I took it on an investigatory.
Yes, they can try that. Obviously, in the case I have, there is no excuse for the lawyer's conduct. He's resigned from the bar, and that's not the issue. But we've had other cases in which we claim that the motion papers were insufficient with regard to a notice of claim, to file a motion for a late notice of claim. Permission to sue a municipality late, you have to make a motion. And the court ruled in that case that the motion papers were insufficient. Well, they fought that by saying that even if the papers were sufficient, how do you know we would have won the underlying motion?
Which is true. So how do you beat that?
I had to get an attorney, a well-known lawyer, to come in and say that in his experience as an expert, had the motion papers been sufficient, the motion would have been granted.
Right. Or maybe you would have to look at other cases similar to this with motions that were filed late that were granted.
One of the experts I had in that case was a retired judge, an appellate division judge, who said, I believe the appellate court would have in fact granted this motion had the papers not been insufficient.
Jurors. Are jurors empathetic to these types of cases, or do they not like to see attorneys sued?
It's the
you
opposite.
Tell me, it's the opposite.
It's the opposite. You can go into the most conservative county you are. This particular case I have pending right now is in conservative county. And it's conservative with regard to medical malpractice cases. Small county, they don't like to see their doctors get sued. But go into the jury room and tell them I'm suing a lawyer.
They love it.
Oh, they love it.
That's
So,
unbelievable.
yes.
All right, let's give the viewers a little tutorial about medical malpractice cases, because I know we're going to want to discuss one particular bill that hopefully gets passed. We'll save that for a little bit, but let's talk about the medical malpractice action itself, because I get calls all the time from viewers who want this discussed because it's an area that they don't really understand. Let's just start first where the client comes to you and says, Mr. Bloom, somebody hurt my mom, or I think hurt my mom in the hospital. I'm not really sure. What do you do? How do you even start it out, really?
I have to get the records.
Okay.
I have to first decide, based on the story that I'm being told by the family member, that there's a case that my office thinks sounds meritorious. It's based on how old was the person. You might have somebody, I got calls today from somebody who's a 94-year-old person who died. Where am I going to go on that case in terms of proving what the life expectancy would have been? So I have to think, are the damages justified? Because for me to prosecute a medical malpractice case, I'm going to lay out $50,000 to $100,000 minimum on the case, getting it ready for trial.
So what would be, in your mind, the damages that you would need to justify expending these types of monies?
Our threshold is pretty close to a minimum of $1 million case.
$1 million.
Right.
Now, it's interesting. I've told the viewers before, my wife's a dentist, and she asks me many times, or she gets nervous about dental malpractice cases, because you always get nervous, and I always tell her, a lot of lawyers don't take dental malpractice cases because the damages are not heavy enough. Is this true?
I've had 2 dental malpractice cases in my 38-year career, and both of them were where the patient died.
So.
Right. It's not, but no one's taking the case. There are some lawyers who will, we won't, where they get paresthesias from surgery, things like that. For the most part, these are not cases we want to handle.
Now, statute of limitations, I want to get right into it. Statute of limitations, in terms of medical malpractice cases, is that when you find out about the malpractice, or is that when the malpractice actually occurs?
The statute of limitations in a medical malpractice case in New York is based upon the last treatment you were rendered for that condition.
So let's give an example with a woman who has a chest x-ray that should have picked up the breast cancer but didn't,
Right.
and finds out too late. And by the time she finds out, nothing can be done, but her statute is run. Give me that example.
The classic case, which is on the internet today, all over Twitter, involves a woman named Lissy McMahon, who is a client of mine. And Lissy is a woman who had some vaginal bleeding several years ago, went to a local hospital. They did a DNC. They looked at the tissue and said, "You're fine." 3 years later, she's diagnosed with stage 4 endometrial cancer. And when the doctors told her about that, they also said, "By the way, we looked at the slides from 3 years ago. They were misread on 12 of the slides that showed cancer."
Wow.
She's out of luck.
Why is she out of luck?
Because the law is that she had 2.5 years from the date of the
Now, that's not her fault, though. She would never know this.
before she even knew she had cancer, the statute of limitations ran.
So what are we doing to change this law?
So there's a law in Albany. They call it Laverne's Law. It's named after a woman named Laverne Wilkinson that made the Daily News and loads of stories about her. A woman, similar story to the one I've talked about, who had lung cancer, went undiagnosed. And we're trying to change the law to say that the statute of limitations should run from the date you can discover it. All but 6 states in the union, that's the law. That it's unfair to say to somebody, statute of limitations can run on a case before you knew about your illness.
Why New York? What's the problem?
The medical society, the hospitals.
Strong lobby.
It's very strong. But the bill is in Albany right now. It's passed the state assembly 2 years ago, almost unanimously from the Democratic Assembly, and more than half of the Republicans in the state assembly, the vast majority of the Republicans. This year in the state Senate, there are 41 supporters of the bill. That's out of 63 seats.
And what do you need?
You need 30.
All right.
Right? So we need John Flanagan and the Republicans to put the bill forward. If they put it forward, it'll either be tonight or tomorrow. The bill will pass.
Well, that would be awesome.
The governor has already come out and said he would sign the bill. We can change the law.
So when will we know?
We'll know tomorrow.
Tomorrow.
Yeah, the
Breaking news.
legislature's leaving tomorrow. We'll know by tomorrow.
So it's a big, big night.
Yes.
For many people who have not had a chance to bring a lawsuit in the past, and maybe their family or somebody else, if this tragically happens to them, they'll be able to.
Speaker Hasty has shown great leadership on this. I know
Yes.
I'm in the Bronx, and the speaker's shown some great leadership.
Well,
on
that's
it.
very, very, very important. Okay, tips. Somebody's watching right now. Let's switch it back. Put your legal malpractice hat on. Thinks they may have a problem with their attorney. Maybe there's a cover-up going on. I'm sure you see this all the time. What do you tell somebody who's watching right now?
You tell them that it's more than a mistake. You see a lot of people calling us, they weren't happy with their divorce settlement.
Okay.
They were unhappy with the terms. Somebody had a criminal trial and they got convicted, and if my only lawyer had done something, the standard is very clear. You have to prove the lawyer was negligent.
So they need to know this.
Yes.
All right. And you're going to come back, maybe in the future, fairly early, so we can find out what happened with the bill, and hopefully the law gets changed.
Great.
All right. We have to take a quick break, but don't worry. We'll be back with more of today's verdict right after this. Stay with us.
We cannot be bystanders.
We can stop to make sure someone is okay.
We can warn someone when their drink isn't safe.
And disrupt the situation.
We can.
Get someone the cab.
Or walk them home safely.
We can make campuses safer for our friends.
Our roommates.
Our classmates, our fellow human beings.
We cannot be bystanders.
We can. Intervene.
It's on us.
All of us.
Learn how and take the pledge at itsonus.org.
How can I help my daughter with her reading?
Searching for help with Dachshund breeding.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I was trying to show you how Sarah feels every day. Frustrating, isn't it? Redirecting to understood.org.
Join parents and experts at understood.org, a free online resource about learning and attention issues to help your child thrive.
And I can't change, even if I tried, even if I wanted to. My love, my love, my love, she keeps me warm. 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 She keeps me warm.
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
Welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Many of our viewers create content without securing the result. Today we'll learn all about long-term IP protection, enforced copyrights, and much, much more. Joining us here today is attorney Stephen Buchwald. Stephen, when we talk about copyrights, trademarks, patents, it sounds the same to me, but they are not the same. Let's start, what's a copyright?
You're right, they're not the same.
Right.
And it's easy to get tripped up. Many people think that they are, but they really aren't the same. So copyright, that's the broadest type of protection in comparison to the other two, patent and trademark, which are narrower. Copyright is basically going to get us protection for anything where there is a spark of creativity.
Give me an example.
So sure, you write a book.
Okay.
And even if it's a book that is completely based on fact, like a biography, the way you created it, the way you wrote it, the thing that you edited, that's creative. And so you get a copyright for that.
So it's a body of work.
Correct.
Itself. Now, how would you even go about doing this? Is there a copyright office? Do you get a stamp? I mean, say I wrote a book. I wrote a book about Today's Verdict. I want it copyrighted. What do I do?
So you actually get a copyright the moment you actually write it.
All right.
When you're alone in your room and you finish writing it, you get a copyright to it.
Okay.
The next step is to let the world know that you did it. And so the best way to do it is to obtain a copyright registration. And that's putting the world on notice that
this is your work.
Right.
Don't take it.
Exactly.
Right now, is there an office that you do this in Manhattan, or how does this work?
So,
or is it federal?
You hire an attorney to do it, but basically, there is a federal register for all these things.
All right.
There is a federal register for copyright, for trademark, and for patent.
All right. Let's move. Okay. Trademark. How is that different than a copyright?
So remember when I said that trademark is narrower?
Yeah.
Copyright is really broad. Trademark is really there to protect your brand name, your product name, your service name. That's it. That's what trademark does.
Give me an example.
So you're launching a new business and you want to make sure that nobody else can use your brand name. You get a trademark and that's going to protect you. And if you see other people down the road that use your brand name, you're going to be able to stop them.
Now, trademarks, are they also symbols or are they just, in other words, like the Starbucks symbol, you know, the mermaid, let's say, or the Nike swoosh, right? Is that a copyright or is that a trademark or something else?
Well, it can be both copyrighted and trademarked.
So that's how I get confused. I don't understand that.
So because it's creative, you know, the Nike swoosh is creative, the Starbucks logo is creative, there is a copyright that can be obtained. But the real value is with a trademark because they use it as a product name, as a service name, in the case of Starbucks, as really their brand name. And so that is a trademark, and that's where the value is, because you sort of get a monopoly over the use of that logo or that brand name or that product name in your specific industry. So that's very valuable.
Now, I guess we're talking about intellectual property here.
Correct.
Property that you own. Do you own it forever? Because I don't think you own it forever. Certainly not with a copyright, am I correct?
So, right. Copyright, patent have terms. Copyright is usually life of the author plus 120 years. For patent, it's usually 20 years. Trademark can run continuously as long as you actually continue using it. So we have big companies that have been there forever, like Walt Disney.
Sure.
They have trademark to, the little castle that you see. That's a trademark, and as long as they continue using it,
it's theirs.
It's
Nobody
theirs.
else can
That's
use
right.
Snow White or whatever it is.
Right.
Well, let's talk about the copyright. Why would we want, or wouldn't we want copyright to end at a certain time so anybody can use it? Why are we just restricting it to the person? At some point, we want it to get into the public domain. Am I correct?
That's right. Well, the reason for copyright, the reason for all these things is to incentivize the behavior, right? So copyright, it's actually in the Constitution. And it basically says that we want to promote the arts and to promote science. And so by getting copyright, you're motivating people to create those beautiful things. But at some point, there is a countervailing objective, which is to let people actually use it and to let people improve upon it.
Which brings me to the term fair use, which I see all over the place when it comes to these particular names, copyright, trademark, patent. What does fair use mean, really?
So fair use is a complicated concept. Right. And it's tricky because there is different factors involved. It's not a simple analysis where you can say, this is okay, this is fair use, or it's not. Basically, fair use allows somebody to use something that is copyrighted in a way where they wouldn't otherwise be allowed to.
Can you give me an example?
So sure. The perfect example for fair use is a parody. So when somebody creates a song as a parody of another song, it's understood that one is not sort of competing against the other. It's its own separate category. And so it's understood that if you're making a parody, most of the time you're going to be able to get away with it.
All right, so if, let's say Madonna has a song like a virgin, and then Weird Al Yankovic comes out like a surgeon, which he has, that's okay. You don't need permission to do that. Is that what you're saying?
Pretty much. It's a little more complicated than that, but that's usually how it works.
All right. We skip patents. Tell me what a patent is.
Sure. So patent is one of the narrower category of IP. And basically, it's only for inventions. So you have many requirements to take into account, but basically it cannot be obvious, it has to be novel, it has to be useful, it has to meet all of these very, very narrow requirements. And if you do, great, you get an invention. But again, not everything and anything can be patented. It's usually for a machine or for a new process or something like that.
I know you're a litigator and you see these types of cases in court many times. Do you usually see copyright infringement, trademark infringement, patent? What seems to be coming into the office that has the biggest action involved?
We see a lot of these cases. They really are all very hot right now. So there is a lot of patent cases. You see the Google and Uber cases and Apple cases that are very, very often patent cases. But you also see a lot of trademark cases as well and copyright too.
Now, I know with respect to the patents, you have these utility patents, design patents. What's the difference? I really couldn't understand that. Really.
So utility patent is what people would probably think of when they think of patent. You want to create a new way of doing something for a machine, an improvement over something else. That's a utility patent. In contrast, design patent is much narrower. It's about the design of products. To illustrate the Apple iPhones, they have design patent over the phone itself. The way it's actually shaped is patented.
Wow, two different things, yet so one product, two different patents.
That's right.
All right. Now, I know you have a French background, right?
That's right.
Patents, copyrights, trademarks, do they move from country to country? In other words, let's say I have this patent from Apple, the design patent, utility patent for the iPhone, and now I go to France and I say, that's my patent. Nobody can make this there. Is it enforceable? Does it work that way?
So it's based on the national territory.
Right.
So if you have a trademark in the US, another company could basically use your trademark in another country and get away with it if you're not there to protect it, if you're not there to first file a trademark and use it in the right way.
You have to refile it in the other
right.
country, so you have to do that.
You have to do that.
Now,
And there's actually easier way of doing it for bigger companies that want to go internationally very fast. There is a Madrid protocol that allows you to, for a trademark, for instance, to file multiple applications at the same time or within a short distance of each other.
What about our country? Do we allow let's say a patent in France or a copyright or trademark? Do we automatically give it credence here, or do we also make them refile and redo the papers?
So for trademark, it's the same in the sense that if you see an amazing brand name or product name, a trademark in Japan, there's actually a case where beautiful brand was basically copied in the US, and then the Japanese company sued somebody in the US and they lost. Because even though that trademark was a real trademark in Japan, it was not a trademark in the US.
Now, are these cases tried in front of a jury? Are they a judge? And let's even start from the court. Is it a state or a federal case? Where do you bring these cases?
These are federal.
They're federal
Patent,
cases.
copyright, trademark, these are all federal cases. And it's going to depend whether it's a jury or a non-jury trial.
And usually, what do you usually see? Jury trials?
You see both cases.
You see both.
Right.
All right. Some tips. All right. Somebody's watching right now and they think they have the ultimate product, invention, symbol. I don't know what they want, and they want to do something.
Right.
First of all, they should contact you, obviously. But how do you do it? What do you do?
So, the first thing to realize is, the first tip is, you cannot protect an idea. An idea in itself doesn't belong to anybody. You have to actually execute it. Whether you want to protect an invention, or you want to protect a brand name, or you want to protect something that you want to do that's going to be the best thing in the world, you can't protect it unless and until you start the process. And so, in the context of a copyright, you can't copyright it unless you finish the book or finish writing the song or whatever it is that you're creating.
So if I write a book, you'll copyright it for me?
Sure.
And you'll come back and we'll talk about it.
That's right.
Fair enough. All right, Stephen, thank you for being here.
Absolutely.
All right, well, that's all the time we have for tonight. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of tonight's show, be sure to check it out at www.bronxnet.tv. Also remember, if there's a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag #Today'sVerdict. From myself and from all of us at Today's Verdict, always remember, know your rights, know your issues, reach your verdict. We'll see you next time.
They said I have troll teeth.
That my voice sounded like a possessed baby doll.
That no one would ever love someone as stupid as me.
That I was fat, ugly.
Disgusting.
The effect of bullying is potent.
We will no longer be the silent majority.
Now, when you see online bullying, there's something you can do about it.
We're gonna take action with the I.
I am a witness.
I am a witness.
I am a witness.
I am a witness.
I am a witness, and so are you.